Over 75% of EEOC sexual harassment charges involve male harassers. So what happens when the accused is a woman and she takes her employer to court without a lawyer? Today, we're covering a case that combines workplace investigations, zero-tolerance harassment policies, and the pitfalls of going to court pro se. So by the end of this video, you will understand how harassment investigations work, why it's important to be realistic about workplace disputes, and why litigation can fail even if you feel that you were treated unfairly. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider, and on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. Recently, I conducted a survey and asked viewers to share feedback on the kinds of topics they'd like to see covered here. And one of the things that the survey revealed was a real interest in understanding pro se litigation. If you're not familiar with the term pro se, it's a litigant who represents themselves in court without an attorney. And today's case is a perfect example because the plaintiff in this case, she represented herself, and we're going to talk about some of the challenges that she faced. But here's the striking part. Even licensed attorneys, especially newer ones, can fall into similar traps. Now, these traps don't just show up in court, they also show up in the workplace. Employees who don't know how to document incidents, retain evidence, or frame their complaints in ways that HR understands can end up losing their case before it even begins. That's exactly why I've created resources on this channel for employees, things like harassment training, videos, free quizzes, and my retaliation response workbook. It walks you through how to document what's happening, how to connect your experiences to the laws that protect you, and how to retain records in case you ever need to take that next step. You'll find the link in the description if you'd like to check it out. Okay, let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. Dorota Peterson was hired in January 2018 as a print and marketing sales associate at the Staples in Jackson, Wyoming. She was over 40, originally from Poland, and spoke with a Polish accent. Like every new hire, she received Staples' Associate Handbook. That handbook had a zero-tolerance sexual harassment policy prohibiting things like unwanted advances, leering, or physical contact. Employees were told to report concerns immediately, and Staples promised a mandatory investigation in response. Peterson understood that policy. She knew that if a claim of sexual harassment was substantiated, an employee could be fired. During her time at Staples, Peterson actually performed well. She got positive reviews and pay raises, and she contacted Staples' HR phone line with questions about her benefits. But not everything went smoothly. In May 2019, Peterson got into a physical altercation with a coworker, Lucinda Thompson. Peterson was accused of pushing and shoving Thompson. Afterward, she texted her store manager, Amanda Rivera, saying she was mistreated by Thompson. Staples suspended Peterson, but Human Resources later found that suspension wasn't properly handled. Let's pause for a moment here because this detail actually highlights something really important about how HR processes are supposed to work. Many companies require HR approval before suspending or firing an employee, and that's actually a very good practice because consistency matters. A local manager might react in the heat of the moment, but HR, they have to look at the organization as a whole to make sure discipline is applied fairly and evenly to employees. There's also legal risk. If a manager acts without HR reviewing the circumstances, the company could be accused of discrimination, retaliation, or even unfair treatment, and that creates liability for the employer. And processes for suspension usually involve putting things in writing, and that record is what protects the organization and the employee if there's ever a lawsuit. When Peterson was suspended after the shoving incident, Staples Human Resources had to step in and reverse it because the manager hadn't followed proper procedure. Then came the turning point. In February 2020, Christian Hernandez, an 18 or 19-year-old sales associate, he complained to the store's general manager, Chris Sabatka, that Peterson, she'd rubbed her breast against him on 2 separate occasions and winked at him while they were working together. Then Staples HR began its mandatory investigation. The HR representative named Lauren Tompkins interviewed Hernandez and another sales associate. Jay Trowbridge, who said he witnessed the behavior as well. Both gave written statements. And on February 19th, 2020, Tompkins and GM Sabatka interviewed Peterson. She denied the allegations, and she then accused Christian Hernandez and Jay Trowbridge of inappropriate conduct. After that interview, Peterson sent a series of text messages to the GM, Sabatka, and the district manager, Sam Fletcher. In those messages, she alleged that she had been harassed by Trowbridge because he had stared at her chest and made comments about wages and benefits. But by then, Staples had already made up its mind because after conducting its investigation, HR decided that the allegations made against Peterson were true. Under the company's zero tolerance policy, she was terminated on February 20th, 2020, just one day after her interview. After her termination, Peterson immediately called the Staples HR phone line, reporting that she had been fired and saying she believed it was discrimination. The next day, she sent an email suggesting Hernandez's complaint was motivated by immigration concerns, that by accusing her, he could secure immigration benefits to avoid deportation. But Staples wasn't buying it. They held firm to their zero tolerance policy, and they dismissed Peterson's counter allegations without further action. And this highlights one of the biggest debates about zero tolerance policies because, on the one hand, they do send a clear message that harassment won't be tolerated, but on the other hand, they leave very little room for nuance or for using cross complaints to avoid accountability. That's why it's so important to understand how harassment policies work in practice. On this channel, I've created full harassment prevention trainings along with quizzes, resources you can use to help learn what harassment is, how to report it, and what to expect when HR investigates. You'll find the links in the description if you want to take a look at those after this video. Then 3 years later, in April 2023, Peterson filed her lawsuit pro se, representing herself. Her complaint included 4 main claims: age discrimination, national origin discrimination, retaliation, and hostile work environment. Now, Staples moved for dismissal and later asked the court for summary judgment, and the district court ruled for Staples, and then Peterson appealed to the 10th Circuit. The appeals court did what courts often do in pro se cases. They said, "We will liberally construe your filings, but we will not act as your lawyer." And here's what that means. Courts will read a pro se litigant's paperwork generously if the language isn't polished or the arguments aren't phrased like a lawyer would. The judge will still try to understand the point that's being made, but when the court says it will not act as your lawyer, that's the limit. Judges will not go looking for arguments pro se litigants don't raise. They won't fill in missing citations. They won't dig through the record for evidence pro se litigants don't point to. So yes, the court gives pro se litigants some flexibility in style, but it doesn't excuse mistakes in substance. If you fail to cite the law, fail to preserve objections, or fail to tie your facts to legal authority, your claim can be lost, no matter how strongly you feel about your case. On appeal, Peterson argued the district court was wrong to grant summary judgment, but her appeal was filled with conclusory assertions, basically claims she made without pointing to any evidence in the record or citing any law to support them, and the rules require that you back your arguments with both legal precedent and record evidence. But she didn't, so the court found she had waived appellate review. The court also looked at her discovery and cost complaints. She said Staples didn't follow discovery rules and that she couldn't afford costs. Again, she didn't provide citations or legal authority. The court said she had waived those issues too, and the judgment for Staples was affirmed. So the long and short of it is litigation, it's about way more than just facts. Whether you're pro se or even a new attorney failing to understand procedure and strategy, it can sink a case. And the legal system, it is designed to be objective, and that objectivity is what's supposed to ensure fairness. But it's also important to remember that everyone involved, everyone from the lawyers, the judges, and others in the profession, they are people. People come with experiences, relationships, and sometimes unconscious biases that can influence how they see a case. Judges, like anyone else, can have good days and bad days. If a judge happens to know the attorney on the other side or has had past experiences that shape their perspective, that can affect how the case plays out. That means you can do all the work, present a strong case and still not get the outcome you hoped for. So it's important to be realistic about what litigation involves. This case highlights how pro se litigants and even inexperienced lawyers can struggle with the invisible curriculum of law, the strategy, the relationships, and the procedural mastery that more seasoned attorneys often rely on. Courts expect litigants to follow the rules. That means citing the record correctly, preserving objections at the right time, arguing on law rather than emotion, keeping complaints clear and focused, and avoiding technical missteps. Pro se litigants often lack legal